Facts: Respondents Evangeline Siton and Crystal Kate Sagarano were charged with vagrancy pursuant to Article 202(2) of the Revised Penal Code in two separate informations dated November 18, 2003, docketed as criminal case numbers 115-716-C 2003 and 115-717-C 2003 and raffled to Branch 3 of the Municipal Trial Court in cities. Davao City. Instead of submitting their counteraffidavits as directed, respondents filed separate motions to quash on the ground that Article 202(2) is unconstitutional for being vague and overbroad. In an order dated April 28, 2004, the Municipal Trial Court denied the motions and directed respondents anew to file their respective counteraffidavits. The Municipal Trial Court also declared that the law on vagrancy was enacted pursuant to the state's police power and justified by the Latin maxim salus populi est suprem, a lex, which calls for the subordination of individual benefit to the interest of the greater number. The Municipal Trial Court also noted that in the affidavit of the arresting police officer, SPO1J Plaza, it was stated that there was a prior surveillance conducted on the two accused in an area reported to be frequented by vagrants and prostitutes who solicited sexual favors. Hence, the prosecution should be given the opportunity to prove the crime, and the defense to rebut the evidence. Respondents thus filed an original petition for certiorari and prohibition with the Regional Trial Court of Davao City, directly challenging the constitutionality of the anti-vagrancy law, claiming that the definition of the crime of vagrancy under Article 202(2), apart from being vague, results as well in an arbitrary identification of violators, since the definition of the crime includes in its coverage persons who are otherwise performing ordinary peaceful acts. They likewise claim that Article 202(2) violated the Equal Protection Clause under the Constitution because it discriminates against the poor and unemployed, thus permitting an arbitrary and unreasonable classification. Article 202(2) does not violate the Equal Protection Clause, neither does it discriminate against the poor and the unemployed. Offenders of public order laws are punished not for their status, as for being poor or unemployed, but for conducting themselves under such circumstances as to endanger the public peace or cause alarm and apprehension in the community. Being poor or unemployed is not a license or a justification to act indecently or to engage in immoral conduct. Issue: whether the Regional Trial Court committed a reversible error in declaring unconstitutional Article 202(2) of the Revised Penal Code. Ruling: the power to define crimes and prescribe their corresponding penalties is legislative in nature and inherent in the sovereign power of the state to maintain social order as an aspect of police power. The legislature may even forbid and penalize acts formerly considered innocent and lawful provided that no constitutional rights have been abridged. However, in exercising its power to declare what acts constitute a crime, the legislature must inform the citizen with reasonable precision what acts it intends to prohibit so that he may have a certain understandable rule of conduct and know what acts it is his duty to avoid. This requirement has come to be known as the void for vagueness doctrine, which states that a statute which either forbids or requires the doing of an act in terms so vague that men of common intelligence must necessarily guess at its meaning and differ as to its application, violates the first essential of due process of law. In the instant case, the assailed provision is paragraph 2, which defines a vagrant as any person found loitering about public or semi-public buildings or places, or tramping or wandering about the country or the streets without visible means of support. This provision was based on the second clause of Section 1 of Act No. 519, which defined vagrant as every person found loitering about saloons or dram shops or gambling houses, or tramping or straying through the country without visible means of support. The second clause was essentially retained with the modification that the places under which the offense might be committed is now expressed in general terms, public or semi-public places. Under the Constitution, the people are guaranteed the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Thus, as with any other act or offense, the requirement of probable cause provides an acceptable limit on police or executive authority that may otherwise be abused in relation to the search or arrest of persons found to be violating Article 202(2). The fear exhibited by the respondents, echoing Jacksonville, that unfettered discretion is placed in the hands of the police to make an arrest or search, is therefore assuaged by the constitutional requirement of probable cause, which is one less than certainty or proof, but more than suspicion or possibility. Evidently, the requirement of probable cause cannot be done away with arbitrarily without pain of punishment, for, absent this requirement, the authorities are necessarily guilty of abuse. The grounds of suspicion are reasonable when, in the absence of actual belief of the arresting officers, the suspicion that the person to be arrested is probably guilty of committing the offense is based on actual facts, i.e., supported by circumstances sufficiently strong in themselves to create the probable cause of guilt of the person to be arrested. A reasonable suspicion therefore must be founded on probable cause, coupled with good faith of the peace officers making the arrest. As applied to the instant case, it appears that the police authorities have been conducting previous surveillance operations on respondents prior to their arrest. On the surface, this satisfies the probable cause requirement under our Constitution. For this reason, we are not moved by respondents' trepidation that Article 202(2) could have been a source of police abuse in their case. Vagrancy must not be so lightly treated as to be considered constitutionally offensive. It is a public order crime which punishes persons for conducting themselves, at a certain place and time which orderly society finds unusual, under such conditions that are repugnant and outrageous to the common standards and norms of decency and morality in a just, civilized and ordered society, as would engender a justifiable concern for the safety and well-being of members of the community. Wherefore, the petition is granted. The decision of Branch 11 of the Regional Trial Court of Davao City in Special Civil Case No. 30-500-2004 declaring Article 202, Paragraph 2 of the Revised Penal Code unconstitutional is reversed and set aside.